Okay, had a little technical hiccup, but I'm back. Hold on. All right. So, what we're going to be doing today, I am looking at a case that I just spilled water on, which I'm going to be doing. I'm looking through it because I'm going to be presenting it tomorrow, and I took a couple of looks through it, and I had a little trouble understanding what was going on. And I thought, well, it's going to take some extra time. And I thought, well, if I'm going to spend some extra time on it, might as well drag you guys through with me. So, we're going to take a look at this. This is a First Circuit Court of Appeals decision that was handed down on Friday. It's in a... This case is a bit of a doozy. That's part of the problem, is that this is a confusing case. So I was a little lost to begin with, and when you throw in what was going on here, it did not make it any easier. So we're going to give it a shot and see if I can get it narrowed down to a nice little narrative that I can present in the morning report tomorrow morning. And I have done this as a sub-chat live because I have a feeling that I'm going to be a little bit distracted. I'm not going to be as focused on the chats today because I'm going to have to be, looking at this, and so I figured I'd narrow them down a little bit while we're looking at this. But I figured I'd let as many people see it as I could. But we're just going to narrow the chat window down a little bit. Oh, there you are. Like, where's the window that I'm looking for? It's over here. Hold on a moment. So what we're looking at, this is a case. Now, there's several cases with the name Doe in them. This is just something, John Doe. It's for some reason or another, the court doesn't want to tell you who they're talking about. And that's not all that, well, I won't say it's not that uncommon, but with what we've been dealing with lately, it's not that uncommon. We've seen probably a lot more of these than you normally would because these are higher pressure cases and a lot more likely to have somebody involved who doesn't want their name and has a pretty good reason for not having their name involved. It's not like anybody can just say, hey, I don't want my name involved. You'd have to have a compelling reason to have your name excluded and have it put in under, John or Jane Doe. But in this case, and in several of these other ones, they've had enough of a reason to be able to do that. Give me 1 second. I'm going to find the district court case number for this one. Where are you? 25 CV 10495. So that I can give you guys a little background. Now, part of the problem here, like I said, is that this one is a little bit of a doozy. And I'll tell you. So here's what happened. Pulled this up. It was on my list of sort of cases that had, something that, I get this list, put together this list of filings that have happened in the last 24 hours, or in the case of the weekend, since Friday. And I sort of go through them to see which ones are going to make it into the morning report on Monday. And I saw that there were some significant things going on here, and I thought this was something worth reporting on. I start looking into it, and I'm like, okay, well, so this is the case about this. And then I see, okay, well, why are all these filings about this if the case is about this? Oh, I see. It's a case about this and this. Cool. All right, so it's a case about two different things. And so why is this filing about this? This is a case about this, this, and this. There are a lot of little parts to this case that make it a little hard to follow, and I have still not figured them out, which is why, for those of you who missed the beginning, I'm doing this as a sub-only chat because I'm going to be a little bit less focused on you guys here, but I thought I was going to drag you through with me and let you talk, or let you see sort of what goes on in my head as we go through some of this stuff, and we'll see how far I can get talking through it out loud, and see how much see how much this works. I don't know if maybe once before I've tried this, something similar. Certainly not with one this complicated. There's going to be a lot that needs to happen inside of my brain here. So trying to do that on a public stage is going to be interesting. We will see how it goes. And I have tried before doing, it's sub-only chat, guys. So it's sub-only chat because I knew that I was going to be a little bit less able to watch the chat today because this is gonna take some energy. So what we're looking at, this is I'm gonna give you just kind of a quick description here. This is a case, it's Doe v. Noem. Again, this is one of these cases where whoever the plaintiff was not only did not want their name known, but was able to convince the court that they had a pretty darn good reason for keeping their name out of this. And so the case is called Doe v. Noem. I'm gonna see do I have, this is what I get for not planning ahead. You know, if I were Attorney Dye, I would have thought of this all in advance, but that's why she's the master. What I'm gonna do here, no, I'm not. Okay. So this is a case, part of this is talking about parole. So parole is something where a temporary status, there's two different, we've talked a little bit about temporary protected status. Parole is something kind of similar. Parole is like a temporary granted thing, whereas temporary protected status is something that's given to like anybody who comes from a particular country. It's where we recognize, hey, if you're here from Venezuela, like things aren't going so well there, and so we're gonna put anybody from Venezuela on a list, and we're gonna kind of let them, for like the next 6 months, we're just gonna pretend you're not here. We'll talk to you again in 6 months, but like we can't send you home right now. Your country's on fire. So that is temporary protected status, and we'll do that for like a whole swath of people. Parole is a little bit more specific, and it's applied for by people, and it could be related to a medical emergency. It could be related to a family emergency. It could also be related to some sort of a political emergency back home. So there are people from Ukraine, Cuba, Haiti, Nicaragua, and Venezuela who've requested coverage under parole. And it does a similar thing. It allows you to come into the United States for a period of time. It's usually about up to 2 years. It does not, on its own, allow you to move into green card status or citizenship or anything like that. It is, I have no other reason for coming, but I need to get there because I need a particular medical thing, and the only place I can get it done is the United States, and there's no other way to, there's no other program that's going to work for me, and so we'll just grant you parole to come here for 1.5 years and get your kidney fixed or whatever. But it can also happen if you are from, Ukraine or something like that. So there have been several of these parole programs that have been specific for getting people over here from Ukraine, from Haiti, from Nicaragua, from Venezuela. There is some crossover between TPS and parole. They are a little bit different, and there was a time when I knew the difference. Right now is not that moment. But I have, when I studied for my immigration exam, I absolutely knew what the difference was, but right now I don't. But I can tell you that they're similar. So here's what happened here. In this case, we have a couple of different things that went on, but one of them was that the federal government stopped processing parole applications for people who wanted to come in, who were submitting parole applications. So that's one of the complaints here under this case, is that they said, hey, we applied and nobody's even processing our applications. Step one. Two, people who were here under already accepted under a parole visa, whatever, under a parole program, were having their parole withdrawn or their status changed or something. And then it appears that there is a third group that I'm not entirely sure why they are involved in this case. I'm assuming we are going to find out in a minute, because parole, like I said, is not a direct link from parole into like getting a green card usually, but for some reason the plaintiffs here are also talking about the fact that their green card applications aren't being processed first, and so I'm not sure exactly why these are all being pushed together into the same thing, unless it just happens to be that this organization represents people in all three categories. I don't know. This has been going on though this case has been going on since February, and one of the things that makes it so complicated is that a preliminary injunction was issued on that one little thing, and different things have been issued on these different issues, and they've been overturned by higher courts, they've been stayed by higher courts, but not all three issues. So they're all kind of moving in different ways. Oh, I have a flash goal. What is that? I never know what these are. 4 gifters sent finger hands in 5 minutes. So achieve this if I do this, then I get something cool. So if anybody wants to send me a finger hands in the next 5 minutes, that would be cool. We have 15 minutes to do it. So if anybody wants to send me finger hands, that'd be cool. Okay, so we have a new Court of Appeals, but the problem is that there are several different appeals out there. We're going to find out what this one is about. One of the things that I would like to point out here... Oh, thank you very much. Woo, we're a quarter of the way there. One of the things that I found here that I think is particularly interesting, because... Oh, thank you very much. All right, we got, is that all 4? I think I got all 4. Sweet. All right. I don't know what that means, but it told me that I needed 4 of them, and then I got something cool. So, 50%. Oh, okay. All right. All right. One of the things that I think is kind of interesting about this is I looked up all 3 judges, because I like to see who we're dealing with sometimes, and see whether there's a story there. Often there isn't. I like to hope that there's not, but I do like to check. And in this case, I think the story is that all 3 judges here, none of them are Trump appointees, and all 3 of them have what I would call non-waspy names. Their names are Gelpi, Gelpi with an accent. Let me find the other names. I gotta find all 3 names. But all 3 of them had, and I was like, okay, well, this is interesting, particularly because in the end, I did, stuck to the end of the book, and it looked to me like they are not going to grant the stay against the government's action here, which is, I think, always interesting when you have that happen. So it's I think it gives us a minute to say, well, this is not. It's nice when you have a moment to say this is not a political issue. Thank you very much, Chuck. So let's start looking at this. This appeal centers on the executive branch's authority to terminate parole grants under the INA. So these are these grants of parole, these things that say you can come in for a little while, and gonna put that in red. I usually put my my issues, my questions in red, and that's not exactly a question, but it's close enough. Parole permits a non-citizen. Okay, here we're gonna have a good definition of parole that's way better than the one I've been using. Parole permits a non-citizen to enter the United States temporarily while investigation of eligibility for admission takes place. Interesting. Okay, so that is a very different definition than I gave you, and mine was kind of wrong. So that explains why some people were coming in and getting having questions about getting their green cards finished, because in my head, parole is not about moving on to a green card, but in some cases, apparently it is. So this is how we learn. Besides allowing legal access to the United States with the ability to work. In some cases, they receive federal benefits. A grant of parole does not, per se, confer additional rights upon a non-citizen. And that's, I think, where what I had in my head, is that I know that it doesn't always provide more. Even non-citizens who've been paroled for years are treated for due process purposes as if they were stopped at the border. Interesting. So if you've been paroled here even for a long time, you're not really here. You're not treated as though you've been here for 10 years. You're treated as though you just walked in. So that's interesting. The INA, which is the Immigration and Nationality Act, empowers the Secretary of the Department of Homeland Security to grant parole of non-citizens into the U.S. only on a case-by-case basis for urgent humanitarian reasons or significant public benefit. So that is what parole is for. It's for an urgent humanitarian reason, which is where I always think of the medical thing, somebody who needs to come in immediately to get a kidney transplant or something. And it's case by case. That's another big thing. This isn't about like TPS where it's like the whole country. It's case by case for urgent humanitarian reasons or significant public benefit. And many presidential administrations have invoked this authority to grant parole to non-citizens. Most relevant is that under Biden, we have this program that allowed nationals of Cuba, Haiti, Nicaragua, and Venezuela, collectively known as CHNV parole programs, who met certain criteria to seek discretionary individual grants into the U.S. for up to 2 years. And there's about 532,000 individuals who received grants of parole under that program. So there's a lot of people here who received this, who had come from Nicaragua, Venezuela, Cuba, or Haiti. But that would have been for up to 2 years. So, then we're going to have our change in facts here, which is that when President Trump took office, he signed an executive order directing the Secretary of Homeland Security to terminate all categorical parole programs contrary to the policies of the U.S., and 2 months later, it published the termination of parole, basically it terminated that program. So that program was terminated by the new administration. Among other actions, it revoked all existing grants of parole in a month's time, rather than letting each expire at the end of their 2-year period. So this is probably what the question's going to turn on, is whether they, with the other thing, the TPS, the court has so far decided that you can't just, the whole point of it is to create some stability for people. And so when they set that time period and say, okay, you have 6 months, you have 12 months, you have 18 months that you are free and clear, you can't revoke that because it's designed, it's actually created with the intent of giving them some stability. And so taking away that stability would be contrary to the intent of the law. So I guess we're going to see whether it's the same thing for parolees. The plaintiffs here, all of whom are affected by the revocation, filed suit and they sought a stay of the DHS action. So that is what they're asking for, is a stay of the DHS's revocation of their thing here. District Court, I do different colors. District Court granted the preliminary request, certified a class of individuals, but the government appealed, and this court is going to vacate the stay of the termination notice. Let's see here. So they are going to allow the termination notice. So that's the end of our story. That's what we're going to eventually get to. Our conclusion is that the stay against the thing that was stopping the government from terminating that parole period is gone, and so those terminations are allowed to continue. And as I pointed out, I think it's really for people who are sort of stuck. Thank you very much. Sort of stuck in that idea that this is all politics, and that even that the court's decisions are all rooted in political decisions. I think it's important to note that that two of these, I think one of these judges is an Obama appointee, one's a Biden appointee, and one is a Bush appointee, I think. But all three seem. I think one is actually, I believe, may have been a Cuban immigrant, or his parents may have been Cuban immigrants. I'm going to be in real trouble if it's from a different island. But Caribbean immigrants, one way or another. So I think that's important because this is really going to be based on the law and not on kind of an emotional response or on a political response. So I think that's important to note. I'm curious about the Dreamers. I don't know off the top of my head, and I don't know off the top of my head. I'm looking through a particular case here, and it's not in front of me. I'm trying to remember. I have a weird feeling that the Dreamer status has not been revoked. I'm just going to stop because that's going to be in my head if I don't. So, all right, this is just me searching the internet in a very untrustworthy way, but it says the current status is that it's facing ongoing litigation, but and that it's not accepting new applications and only processing renewal requests. So, I'm sure I'll see it at some point. It'll come up on my list, but I didn't know it off the top of my head. And again, that is not a well-reasoned search. Oh, you know what I forgot to do? In case I sound weird, it's because I forgot to put my mic on. Let me see here. That might... I don't know if that makes it better or worse. Let me know if that makes it better or worse, guys. Okay, so now we're going to see why. And we are breaking this down in a lot of detail here. So let's see where we... So we begin by orienting the reader. I love it when they walk you through this with your, they hold your hand to do this. We begin by briefly orienting the reader with the relevant statutory regime. And I've told you guys before, these cases are going to follow a very specific pattern. They're going to give you the facts and the issue and then the rules. What they're saying here is we're going to lay out the rules now, the statutory regime. So for the next couple of pages, they're probably going to be just talking about what the rules are. Explaining first the underlying facts and then the procedural. So they're going to go facts and then rule. All right. Okay, so Section 212 grants the Secretary discretion to parole non-citizens into the U.S. And here's what it says. I'm going to sort of scan this and give you if there's any meat here. In the Secretary's discretion, which is important, fully in the discretion of the Secretary, that's a big deal. Parole into the U.S. temporarily under such conditions as he may prescribe only on a case-by-case basis for urgent humanitarian reasons or significant public benefit. And I'm following a footnote here, see if it tells us what significant public benefit means. Deemed strictly in the public interest. So, I don't know what that means. I suppose we'll get there eventually. any alien applying for admission to the U.S., but such parole shall not be regarded as an admission of the alien, and when the purpose of such parole shall, in the opinion of the Secretary, have been served, the alien shall return or be returned to the custody from which he was paroled, and thereafter his case shall continue to be dealt with in the same manner as that of any other applicant for admission to the U.S. So this is very different from temporary protected status, which is supposed to set up a time period and say, hey, you are free and clear for 18 months, and it's supposed to create stability. This, by contrast, is supposed to completely, and I'm just reading this here, but it sounds like completely at the discretion of the Secretary, allow for the person to kind of take a, even if they were in line before, step out of line for a little bit while they're dealing with this particular situation. And then as soon as the Secretary decides, oh, thank you, oregano. As soon as the Secretary decides that that situation has ended, they step right back into line wherever they were or whatever situation they were in. If that means they're sent home, if that means they're put back in the visa line, if that means whatever it was, that is where they're put right back where they were when this started. That's what this seems to say right here. I'm going to put a little green around here so that I remember. Green are my my rules. My roles. There's my I got a little bit of Ohio in there. Let me just highlight, because I think in the opinion of the Secretary is incredibly important there. That's a fair amount of discretion. That's very different language than we're seeing in some of these other laws. So, thus, parole allows the Secretary, in her discretion. It's kind of funny that there's, the statute keeps saying his, but the Secretary is a woman, and so they keep flipping back and forth. To allow non-citizens to be physically present in the U.S. without being legally admitted to the U.S. Its purpose is to permit a non-citizen to enter temporarily while investigation of eligibility for admission takes place. And I feel like this is part of what's been confusing me, is that on the one hand, they keep saying that they're taken out of line to figure out if they're admissible. On the other hand, it seems to say they're taken out of line to deal with a temporary situation, a humanitarian situation. So those two aren't the same thing, which is a little weird, but either that will be resolved or it won't. But I'm just noticing that those two things aren't necessarily lining up, and it may be why I've been so confused coming up to this point. Since the late 1990s, every presidential administration has exercised the parole authority, including Presidents Clinton, Bush, Obama, Trump, and Biden. Okay. So, CHNV parole program, and this is the one about people from Cuba and Nicaragua and Venezuela. In 2022, the DHS under Biden announced a new parole process to address an increasingly high number of encounters with Venezuelan nationals at the southern border. Implementation of a parole process for Venezuelans, let me just, implementation of a parole process for Venezuelans. This new process allowed Venezuelan nationals to obtain advanced authorization to travel to the U.S. to seek discretionary case-by-case grant of parole for up to 2 years. Modeled after the Venezuelan parole program, DHS launched a similar program for nationals of Cuba, Haiti, and Nicaragua in January of 2023. So essentially, rather than having people show up at the southern border, at the Mexican border, and say, hey, we're here from Venezuela, and things are really bad there, and we have to just stand here and explain all of this to you while we're standing here in line, and there's just this huge line of people, and the number of people who are coming from Venezuela was really high, and it's kind of gumming up the works. The Biden administration said, okay, we are going to set up something in advance because we know that like 5% or 10% of the people in line are going to be saying the exact same thing, and we're going to set up something so that they can start up filling out their paperwork in advance or something to kind of stop gumming up the works and do this separately. We are reviewing a First Circuit Court of Appeals response in Doe v. Noem. This is one that I'm going to be putting in the morning report in the morning, and I was just having, it just wasn't making a lot of sense to me, so I figured if I was going to fight my way through it, I might as well do it with you guys. So that's what we're looking at right now. The case number is 25 CV 10495. The First Circuit number is 25-1384. That's 25-1384 if you guys want to look it up. It's about 38 pages long if you're curious whether you have the right one. And I am just hitting page 8. Okay. So that is basically what they did. They were trying to de-gum the works a little bit. Okay, that's awesome. I'm glad I've created some interest. Okay, so it's modeled after. So once that was working, apparently it did actually fix the problem a little bit because they ended up doing the same thing for Cuba, Haiti, and Nicaragua. I would imagine, particularly in that time period, there was probably a big swell of people from Haiti as well, I could imagine. I'm trying to remember what was going on in 2022. Yeah, it's much easier to do. Well, yeah. Okay. So let's see here. So implementation of the parole process for Haitians. No, they're just going through, yeah. In doing so, DHS justified establishing this parole program on 2 general ideas. First, significant public benefit, and second, urgent humanitarian reasons. So 1 is significant public benefit, and 2, urgent humanitarian reasons. And I was wondering what significant public benefit meant, so I guess we are going to find out here. Let me mark 1 and 2. More specifically, DHS said that the program would serve a significant public benefit by 1, enhancing border security, 2, improving the vetting of prospective parolees, 3, relieving the effect of increased migration on DHS's workflow and resources, 4, reducing the strain on border communities and domestic resources, 5, incentivizing aspiring parolees to enter the United States safely and lawfully, and 6, fulfilling the administration's foreign policy goal to collaboratively manage migration. So, I just kind of ran through that, but essentially the idea here is that the public benefit that they're talking about is, in case it didn't make sense, making the border work better. One of the biggest complaints, and I've talked about this before, but one of the reasons that the immigration system has always been so messy is because it's been underfunded, and yeah, that's a big part of it. It's just that there are, there's too many people trying to get through the border. A lot of the sort of people going around the actual official process has more to do with the fact that it can take days to get through it than the fact that it's not possible to get through at all. It is possible to come into the United States for a short period of time, and if you live, for example, in Mexico, close to the border, and you wanted to go back and forth on a regular basis, it wouldn't always be that big of a deal, except for the fact that the border takes hours and hours to get through. If it were a little bit of an easier process, it has been surmised, a lot more people would go through it in proper ways because they're not trying to break the law. They're just trying to get across to go get whatever they need to get done. Go to the store, whatever, and come back. And in cities like San Diego, that's really common for people to just go across, go to the store, and come back in both directions. So, but usually, if you're coming from the south north, you kind of have to set across a couple of days, because you set aside a couple of days, because it takes you so long to get through the border that even if you just want to run to Walmart or Home Depot or something, it's going to take you 6 hours to get through. So it's like, well, you might as well stay for 3 days. So there, anyway, the idea here was to cut out, if we know that 10% of the people coming through the border are all going to be asking the same question, why don't we try to set it up so that they're going through a separate line, so that they're doing their paperwork in advance, so that they're not gumming up the works like they are. And that's the theory here, is to try to administratively fix some of these problems. That is what is meant. What I'm getting at here is that is what is meant by that public benefit, significant public benefit prong of this question. The urgent humanitarian reasons we'll get to in a second. Let's see. But let me set this aside so I don't forget that this is public benefit. And by the way, when you're reading these cases, writing and is how we remember this stuff, because I'm going to have to go back through and read this again later and remember what I read. So my notes are going to be key here. All right. Now let's see if we can find where they talk about urgent humanitarian. Here we go. As for the urgent humanitarian reasons, the DHS stated that these parole programs would address the needs of nationals from Cuba, Haiti, Nicaragua, and Venezuela who sought to leave the political instability, social unrest, or dire economic conditions in those countries. So, and I figured that would probably it'd be an answer, something like that, but now we have that written down. All right. But being a national of one of these countries did not guarantee parole. Actually, that's probably a good point too, because part of what they were saying is that they wanted, rather than have people show up at the border and apply for parole, they wanted them to start applying from Venezuela and get an answer, so that they didn't come up and gum up the works just to find out that they couldn't come in, rather find out before they left, which may or may not stop them, but at least it was a little different than having an answer before you left and having to sit and go through all of that right when you got there. Let's see. Excuse me. So the program required each applicant to meet certain requirements. One, this is interesting. They had to have a supporter based in the United States. I'll mark this. This is not uncommon. A lot of people, in order to come into the U.S., need to have somebody here to demonstrate that they're not coming in to become any kind of a burden on the U.S. That there's somebody here who's going to be taking care of them, and often that person needs to demonstrate. I don't know about here, but often that person needs to demonstrate that they have enough money to take care of them when they get here. That is a very common thing that has to happen with certain types of marriage visas and things like that. If you want to get a visa to come to the U.S. to marry someone, like a fiance visa, that person's going to have to demonstrate that they have a job and that they're making enough money. Not you. You can't come here if you're going to make enough money. That's not allowed. The person who you're coming to marry has to make enough money to demonstrate that they can support you, so that the government isn't stuck supporting you once they let you in. So that's the way it's always been. That's nothing new. So this is a pretty common thing. To have a supporter here, pass a national security and public safety vetting, which is another nice thing to do before they walk to before they're sitting at the door, right? That takes time, so it makes a lot more sense for them to apply for that, weeks or a month in advance, so you have time to figure that stuff out before they before they're knocking. and comply with other requirements. Once paroled, they could seek other immigration benefits or work authorization in the U.S. during the 2-year parole period. Okay. In 2024, DHS announced that it would not renew or extend parole periods beyond the initial 2-year period. Okay, so that's important. So this is prior to the Trump administration. The Biden administration said, we gave you guys 2 years, and that's what we gave you. We gave you 2 years, and that's what this was for. But this isn't getting redone. So the parolees who did not receive other immigration authorization would have to leave at the expiration of their parole period. Now, so they could have, while they were here, if they had some reason to apply for something else, they could do that. But if they didn't, then when the 2 years ended, you got to go home. Or else the government would put them in removal proceedings. So, all right, shortly after taking office, all right, so here we go. This is 2025. President Trump signs 2 executive orders directing the secretary to terminate all parole programs that are contrary to the policies of the United States, including this particular parole program. And take all appropriate action to ensure the parole authority would be exercised on only a case-by-case basis. I'm not sure why that was any different, but I guess we'll see in a minute. So Ben Huffman, who was the acting Homeland Security chief at the time, published a memorandum about the exercise of parole authority, providing that this particular law, which I'm not sure which one it is, probably just the parole law, applies in narrow circumstances only on a case-by-case basis, does not allow authorized categorical parole programs. Oh, so I think what the Trump administration said is that when they got in, that their read of the parole law was that paroling a group of people like Venezuelans was not what the law was written for, and so anyone who had been paroled as a group was violated the law. That was their read of this. So and so essentially they're just immediately going to say anybody who was violated as a group, you're gone. To address that apparent inconsistency, the memorandum ordered ICE, USCIS, and Border Patrol to review all parole-related policies, identify those that were not strictly in accord with their reading of that law, and develop a plan to phase them out. Pending this review, DHS would have the discretion to pause, modify, or terminate any parole program. Okay. Termination notice in the Federal Register. The Federal Register, CFR, is kind of where all the regs are kept. It's like we've got the laws, and then we have like this book of everything that breaks down what the executive branch, how the executive branch wants the laws to be implemented. Okay. March 25th, DHS published in the Federal Register a termination notice stating that DHS was terminating categorical parole programs for inadmissible aliens from Cuba, Haiti, Nicaragua, and Venezuela, and their immediate family members, termination of parole processes, and further specified that temporary parole period of aliens in the U.S. under this program that had not already expired by April 24th would terminate on that date, unless the Secretary made an individual determination to the contrary. So, en masse, everybody's going, unless we pick out somebody who we think should be able to stay. Accordingly, the termination notice explained that the parolees would have to depart before their parole date. So before April 24th, everybody's got to be out of the country. What date did they issue that? That was March 25th. So they had 1 month to get gone. Termination notice provided several reasons supporting their decision. Explained that the termination was appropriate and necessary because the parole program did not serve a significant public benefit. So they did not feel that it did serve a significant public benefit. They were not necessary to reduce levels of illegal immigration and did not sufficiently mitigate the domestic effects of illegal immigration. So, unlike the Biden administration, who felt like they were the purpose of this was to kind of make the process smoother and cleaner, the Trump administration didn't really care about that. That wasn't what they were worried about. This was no longer a priority of this new administration. The new administration was more about getting as many people out of the country as possible, and this wasn't really furthering that goal. So, go home. By the way, anybody who's... Oh, shoot, I can do this, can't I? Check this out. Wait, let's see. Oh, really? Oh, well, okay, never mind. I just figured out how to sell mugs through TikTok, and I think I probably had to set it up at the beginning, but I'm pretty excited about that. Oh, yeah, if you guys are in here, will you tap the screen? I would appreciate that. Thank you. Okay. So, oh yeah, so if anybody wants to buy a mug, you can buy them on my profile. I thought I could do it right here, but I guess. Let's see. Let me see. All right, give me a second. It's saying, you know they can see you, right? And I'm like, yeah, I know they can see me. Let's see here. Let's try that. Oh. Did that work? All right, so if, I don't know, it says it may have worked. I don't know. If you can see a mug, that's this mug. Although, actually, I think I made the duck a little bit bigger on the new one because I thought it was a little small. Okay. That's I had to find a way so I could afford to keep doing this. So, I'm selling mugs. I've got t-shirts, too. All right. So this is basically the idea, is that the public benefit, the idea that we're trying to, it's in the yellow shopping bag. Okay, cool. All right, so it's working. Sweet. All right. So that's the idea, is that, whereas before this was considered a public benefit, this was something that was helping things, the new administration has a different set of what they're trying to fix, and so it doesn't work anymore. Okay. Let's see here. Termination notice also stated DHS believes that the consideration of any urgent humanitarian reasons is best addressed on a case-by-case basis. The two prongs here are, one, public benefit, and two, humanitarian. It's supposed to be both of those things. And they're saying we don't see a significant public benefit, and if there is a humanitarian... Oh, thank you very much, Dog Fan. I appreciate it. And if there is a reason, if this does benefit the humanitarian thing, then we'll deal with that when it comes up on an individual basis, but not as a whole country. And particularly, I would say that, this administration feels particularly that Venezuelans are maybe doing something nefarious, and so that would be particularly an issue, potentially. So they'd really want, it would be in line with their kind of set of rules to go through them one by one. Just logically. All right, moreover, the termination notice examined the potential reliance interests of supporters and beneficiaries. The termination notice explained that the temporary and discretionary nature of the programs indicated reliance on continued existence of the programs would be unwarranted. That doesn't seem like English. All right, that didn't seem like it was in English, but I'm just going to move past it. The termination notice explained that the Federal Register notices issued notices issued during the Biden administration establishing the program expressly stated that the Secretary and DHS may terminate parole at any time. So, And that seemed to be what the law said, that the secretary is allowed to terminate this parole at any time. Termination notice also noted that on October 4th, the Biden administration announced that there was no re-parole, which is also true. Termination notice then discussed, so we're just going through all the things they noticed. Let's see here. The termination notice discussed the potential reliance interests of prospective supporters and prospective beneficiaries. Prospective beneficiaries with approved advanced travel authorization and their supporters, and the current parolees. As to each group, the DHS concluded that the government's interests outweighed the reliance interests of prospective and current supporters. Okay. All right. So there's this concept. Usually, mostly... Oh, thank you very much, Tiff Live. Usually, you'll see this mostly in contract. It's something called reliance, which is... it basically restricts you from taking something away if other people have properly relied on it. So, and really put stuff into that reliance. Thank you, Oregano. So the idea that you really do see this more in contract, where the question of whether you've violated a contract or not sometimes comes down to whether or not the people on the other side have actually relied on you fulfilling that contract or not, and whether they've really put grease and money into the fact into assuming that you were going to pay out and you were going to do what you were supposed to do. So the idea here is that if the country, if we had said you've got 2 years, and that is a definitive 2 years and it's never going to change, and a lot of people had done things like sign 2-year leases as a result, that might be a good reliance argument. Especially if they had like prepaid some of the, they'd like prepaid a 2-year lease to stay here because you'd promised them that they could be here for 2 years. So they'd relied on that promise to spend all of that money ahead of time. That would be a reliance argument. And like I said, usually a contract argument. But what they're saying here is that these guys these guys really didn't have any reliance argument. It's probably not a necessary thing for them to point out, but it does kind of add a layer of strength to their argument here. And the reason they're saying is that at the end of the day, if you kind of break them down, any reliance that they may have had, considering the fact that they would have known from the beginning that these parole options were kind of flexible. They were always flexible. They were explicitly flexible, unlike that TPS thing. The government's interest in canceling them, if they have a need to do that, is higher than anybody's reliance on this. They should have known if they were prepaying a 2-year lease, that was probably not a great idea, because they had never been promised that this would last 2 years. So, all right. So that's reliance. Reliance is a really fun kind of... one of my favorite things about contracts is the kind of economic side of contracts. And I had a professor who was really into like the econ side of contracts. Hey, heuristic raccoon. And that was really kind of where he came from and where we really focused. And there was a guy named Judge Easterbrook who was really like an econ guy. And so that was looking at kind of the econ side and balancing out the outcomes of choosing one side or the other in a contract dispute, and how much of an effect that's going to have on like business in general is really fun and interesting. It makes that's why I love contracts so much. There's so much econ in it, and so much anyway, it's fun. All right. Side note. With respect to the current parolees specifically, okay, DHS considered 2 alternatives to early termination. One, let me mark that, I think this is important. One is permitting the people on existing grants to remain in effect until their grants expire. and 2 was implementing this kind of wind down period of more than 30 days. But DHS rejected those alternatives because it interpreted a different provision of the INA to prohibit the use of expedited removal proceedings for ex-parolees who had been continuously present for more than 2 years. Huh. Okay, we're going to have to talk about expedited removal for a minute. So, expedited removal, if you haven't heard it from me before, basically when you walk up to the border and you knock on the border and say, "Hello, I would like some America, please," the border person, the border officer, is allowed at that moment when you have just gotten to the border to say, "No, no, turn around, go home. You do not have the right paperwork, you don't have whatever, you are not allowed in." And even though that may seem like they're not letting you in, we call that a removal because sometimes it happens inside the border. It's allowed to happen up to 100 miles inside the border. Because I don't know if you guys know this, but especially before 9/11, you didn't necessarily get checked at the border all the time. I used to go to a place in Canada where we would cross the border and then you'd have to go find the border agents wherever they were and check in. It was like a thing. So it's not always right at the border, but when when you're within 100 miles of the border, and they're like checking you in, like you're still considered like you're walking in for the first time, sorta, they're allowed to just look through your paperwork and be like, "I'm sorry, but you don't have the right paperwork. You got to go home, or you got to go back across the border. You're not allowed in," and that is called expedited removal. This is still considered your due process. You're still given your due process, but it's a much shorter due process when you're kind of first walking in and they're checking you essentially, theoretically, for the first time and deciding whether or not all of your paperwork's in order. That's called expedited removal. We have some legal questions right now because the administration is trying to use expedited removal like in Indiana or in Chicago, or like in the middle of the country, which is not what it's designed for. And so there are questions about that. But here what they're saying is that there are certain laws that they've found that say once someone has been here as an ex-parolee for long enough, they are no longer allowed to use expedited removal for these guys. And so they needed to get them out. They were going to let them stay through their 2 years or whatever, but then they might lose the ability to remove them at the end. And they couldn't allow that to happen, so they're going to go ahead and kick them out right now. That is their reasoning. I don't know if it's true or not, but I will tell you that in this case, what I'm looking at is a court doc. This was written by judges, not by one side or the other. Usually when you read something that's like written by one of the parties or the other, you got to take it with a grain of salt. This is written by the judges. They're not saying that this is correct yet, but chances are they would have said, they said this, but if it were totally off base. So it's probably not totally off base. So that is what they said. We considered allowing these guys to stay for a couple of years and just letting their time run out. But the problem is that the way that we read the law, if we do that, we may not be able to get them to leave at the end of 2 years. They might have like squatters' rights, basically. So we decided under the circumstances that we just had to say, "I'm sorry, you got 30 days and you got to go." So DHS explained that permitting existing program participants to remain until their terms naturally expired would jeopardize its goal of expeditiously removing these parolees with no lawful basis to remain using expedited removal proceedings. That was their goal. They wanted, at the end of their term, they wanted to say, "Okay, you got to go now." And they may not be able to do that if they waited all the way until the 2 years were over. I don't know if it's true, but that's what they're saying, and the court here is not necessarily disagreeing, or at least not yet. It reasoned that permitting ex-parolees to remain in the country for more than 2 years would further tax the already overburdened immigration court system. Let me put that into... by requiring the use of regular Section 240 removal proceedings. So they're saying that if they had waited, then all of these guys were going to be going through the long version of immigration hearings instead of the short one. And we've already got enough going on in the immigration courts. We don't want to add 500,000 more cases to these hearings that are unnecessary. Thus, it adopted the early termination approach so that it could retain its ability to initiate expedited removal proceedings to the maximum extent possible. All right. Whew. After so now we are going on to procedural history. So procedural history, by the way, in a case is usually where they tell you about kind of the back and forth after this case started. It's going to tell you, okay, this went to this court, and then it went to this court, and then this person filed this, and this person. Procedural history is usually what happened after the case was filed. So that's the section we're about to start. So about a month after President Trump directed the secretary to terminate the parole program, plaintiffs sued the government in District Court of Massachusetts and published, DHS published termination notice, and 2 days later, plaintiffs moved for a preliminary injunction. Let's get another color here. I usually don't have issues with scope. It seems harder to get lower court stuff. That's, yeah. Let's see, what webpage do you normally go to? So what I usually do, courtlistener.com. Courtlistener.com is essentially a repository for court dockets, for federal court dockets. It just basically downloads all the files, and most of them anyway, and makes them available to you, at least all of the important ones. You used to have to go through Pacer, which meant you had to pay 10 cents a page or something, or 5 cents a page, whatever it is. These guys basically have gone through, and I think they're paying, I don't know, and they're downloading all of them and making them available online. Courtlistener.com. So what I usually do is I will type in that the case number, which is usually going to be the year dash which court it's in, so CV, so 25-CV-10495, and then I'll put a space and then type all one word Court Listener, and it'll usually bring up the link for this case to Court Listener, and you can open it up and it'll have the entire docket, date by date, and let you kind of sift through it and open up each document and look at them. So that's where I find these. Now this one in particular is that number, that 25-CV-10495, that is a district court number. It's probably linked in there, but this is actually a Court of Appeals case. I'm not sure if it's also going to be on there. Worst case scenario, you can go on the First Circuit Court of Appeals website and just look up opinions. This is Doe v. Noem, and it just came out on Friday, so it should be on there. But yeah, there's a little bit of trial and error on finding these things. I used to have access to Westlaw, but for right now I do not. So nobody can afford Westlaw on their own. It's too expensive. All right, procedural history. About a month after they filed, plaintiffs moved for a preliminary injunction and a stay of the truncation of the grants of parole. So the two things they wanted were preliminary injunction, and they wanted to stay the DHS's cutting short of these parole grants. Yeah, Westlaw is very expensive. And I believe, if I'm understanding correctly, that what we're dealing with here in this Court of Appeals case is the stay. April 14th, District Court issued they granted the plaintiff's motion, so they would have probably granted, specifically, the District Court stayed DHS's action so far as it revoked, without a case-by-case review, the previously granted parole. So that is an interesting way to look at this. So instead of, the government felt that these should only be granted on a case-by-case basis, but the court said, well, they can't be revoked on a case-by-case basis either. That is interesting. So that is what they're saying here, is that they stayed DHS's action insofar as, where they revoked the parole and work authorization without going through a case-by-case review. But that is an interesting read of this law. I don't know if you guys can tell, but I already sort of have an opinion here. I'm trying to keep it to myself, but we'll get there. It also stayed individual notices of parole revocation. Oh, but sometimes I'm wrong, by the way. Sometimes I think I have an opinion, and then it turns out to be totally wrong. It happens all the time, and I kind of love it. It's fun. It also stayed individual notices of parole revocation pursuant to the termination notice sent through USCIS Online. So I guess they probably sent out like a mass email or a mass system message that said, hey, all of you are screwed. And this case stayed that mass email or mass notification of whatever sort. In determining whether to grant okay, so now we're going to go. So that was the stay. They requested two things, that and a preliminary injunction. And in determining whether to grant preliminary relief, the district court evaluated 4 factors. If you haven't picked up on this yet, hold on. I'm just going to... Can I do this real fast? Yeah, whenever a preliminary injunction is issued, actually the same with a stay usually, but especially with preliminary injunction, as a general rule, they're going to go through a 4-part test. Sometimes it's a 5-part test, but it's always basically the same test. And it can be a little different, but it's almost always exactly the same. And let me see here. Let me see if I've got... All right, so we're going to go over to the whiteboard for a sec. Boop. Up we go. And let me make sure that I have this pointing in the right direction. Or if I have to do this backwards, let me just check. Is that going the right way? No, it's not. All right, I got to flip you guys backwards. Give me 1 second. Try that. There we go. Ooh, I'm running out of whiteboard juice. I gotta put that on my wish list. Okay, so there's 4 questions, and this is whenever you see a preliminary injunction, these are going to be the 4 questions that they're going to ask. All right. 1. Make sure I'm on. Okay. 1 will be likelihood of success on the merits. So, basically the idea is the court is issuing a preliminary injunction. This is called an equitable remedy. It's like, by equity they mean like fairness. They're issuing like a fair remedy. It would be really unfair if you were able to come into court and get the court to do something. This is just temporary while the case is going on, right? It'd be really unfair if the court did something, put something in place temporarily, and let you get away with something for like 6 months while the case is going on, that at the end of the day, you weren't going to win. Like, you were absolutely not going to win. So this would become essentially a way for you to get around having to win your court case. You could just bring a losing court case and get a preliminary injunction for 6 months and get what you wanted anyway. So the first thing you have to show is that you are likely to win, okay? Likelihood of success on the merits is the first thing. Second is irreparable injury. So 2, irreparable injury. So whoever is requesting this equitable relief needs to show that if they don't get it, they're going to get injured in a way that is irreparable, that they cannot fix later, okay? And money is almost never irreparable. Very rarely is it irreparable. You have to prove really a lot to if it's just money, because most of the time we'll say, okay, well, they just pay you back in 6 months or a year. That's not irreparable. We just pay you back. But if your house is slowly sliding off the edge of a cliff, and if the court doesn't intervene and make them stop digging away at the sand underneath, it's going to keep falling. That's irreparable. So they will stop. They could stop that. That is an irreparable damage. The house is going to fall the rest of the way down if somebody is digging on the at the bottom of the cliff. That's irreparable damage. Okay. 3 is whether issuance of the preliminary relief will substantially injure the other parties. Okay. So, whoops, that's 3, not 3. Substantial injury to other party. So if you're the one requesting this relief, what happens to the other guys if they go ahead and give this to you? If the court makes the guys who are digging at the bottom of the cliff stop digging while the case is going on, how is that going to hurt them? Is it going to be substantial? What is it going to do to them? Are they trying? Do they have family members buried in there that they're trying to get out? Is that more important than your house not collapsing? And so that's what they're going to consider in this third thing. How is it going to affect the other party? And finally is a public interest. The public interest. How does this impact the public? And that could be something like if the court in general starts doing things like this, how is that going to change things for the way people see the court? How is that going to change things for the way people start filing cases? If we start, giving away the store here, is everybody going to start filing lawsuits because they're going to be able to get preliminary injunctions? How is that going to impact everything? These are just things that they should think about. But also, if in our collapsing hill scenario, maybe there's a school right next to the house. And so not only is the house going to collapse, but the school's going to collapse. Something like that. But they're going to consider that's not a great example. It's usually something more theoretical, more philosophical. But public interest is going to be the fourth factor. Now, sometimes these are going to look a little bit different than this, but as a general rule, they're all going to kind of look like it's good. If this is what you're thinking of, like sometimes it's gonna somewhere like 3 or 4 is going to be called the balance of the equities, which means look at how this affects both sides and see who ends up on top. That's called balancing the equities, but you can see that that's sort of like looking at the irreparable injury, looking at how it substantially injures the other party, and consider the public interest. It's sort of the same thing. So one way or another, think of these 4 steps. This is they're using the 4 steps here. It's not always going to be the same, but it's always going to be the same idea. So that's what, whenever you're thinking about equitable remedies and we're talking about stays and preliminary injunctions and things like that, it's going to be something like this, even if it's not exactly like this. All right. So I think that will help you guys in the long term. Let me mirror you back and we'll go back over here. I'm so excited about figuring out that the whiteboard can be, I can just swivel over there. Now I gotta move you down so I'm not totally out of screen. Yeah, the court is usually kind of resistant to subjectivity, but that's why it's the fourth factor. So subjectivity is almost, when you have those fourth factor tests, the fourth one is almost always subjective. You'll find. I've found over time. There's usually one in there that's a little subjective when there are 4 or 5 factors. But it's always the last one, and it's always like theoretically an afterthought, but you know, it's still there. All right. Now, in determining whether to grant preliminary relief, okay, yeah, so we're looking at the 4 factors. Okay. First factor, the district court decided that 3 reasons indicated that the plaintiffs were likely to succeed on the merits. So remember, they have to be able to win. Is it fair to assess that if they can get the first 3, they don't bother with 4? They always go through all 4. They always go through, and like I said, sometimes they will combine several of them into one, but you can usually see hints of all of them in there. Even if they say, oh, we're going to go through the 3 factors, you'll see that all 4 things are still being considered. Sometimes it'll be 5 factors, and you'll see that it's still another way of breaking down those 4 general ideas. And I am pretty sure that if I were a little more observant, I would be able to tell you when they use the 3, when they use the 4, when they use the 5. There are specific actual rules about when to use what, but A, I can't remember, and B, it really doesn't matter, because at the end of the day, they're all vaguely going to look like that. And so as long as no one's asking us to write any of these things and we're just kind of learning them in the abstract, I think that's okay for now. Hey, Allison, how's it going? All right, so let's look at how they looked at the considering the likelihood of success on the merits, which is the first one. And anybody who sat through and listened to my my talk about rational basis review the other day, the first reason is that DHS lacked a rational basis for disallowing parolees' grants of parole to expire naturally, because the stated reason was based on a legal error. So they are saying that they failed rational basis review, which I told you the other day isn't really a thing. Since Justice Breyer left the court, I don't think failing rational basis review has been a real thing. But they are saying here that they have failed rational basis review because the reason that they stated here was there was a legal error here. DHS justified terminating these grants within 30 days because any longer would have foreclosed their ability to deport people using expedited removal. So remember I said that they were worried. Why is that tied to Justice Breyer? Because he was the one who used to do it. He was the one who used to come in and say, he was the only one who came up with examples where rational basis had a little bit more teeth to it. We called it rational basis with teeth or rational basis with bite. It was like rational basis plus a little bit, and only Justice Breyer, I think that's the justice, I think that's the right one, would ever exercise it that way. So remember I said a minute ago that they were worried that if they allowed people to stay here for 2 years or longer, that they would lose the ability, they would become basically like squatters, they would lose the ability to move them out more quickly through the expedited removal process like they'd just gotten to the border. And the district court here said no, because the district court said that persons who are authorized to enter the U.S. are not subject to expedited removal regardless of how long they have been in the United States. Which I'm not sure is correct. But the second reason, so she had said 3 reasons that they failed the merit-based test. That was number 1. The second reason was that the test of parole authority supported plaintiff's position that parole termination must occur on an individual case-by-case basis rather than rather than on the categorical basis employed by the Trump administration. So the Trump administration said, you're not allowed to grant this to an entire group of people. It has to be case by case. And they're saying, no, that's not true. And then 3, the plaintiffs made a strong showing of likelihood of success because the termination notice did not address the humanitarian concerns. So remember that there are 2 factors here that have to be met. One is the humanitarian part, and the other is that it's good for the public. So in addressing the second factor for granting a stay, so the second factor is going to be irreparable injury. The district court determined that plaintiffs were likely to suffer irreparable injury absent a stay. For which I will say, I mean, if you get sent back to Venezuela, that might be an irreparable injury. For in the absence of a stay, the district court reasoned plaintiffs would be forced to continue following the law and leave the country on their own or await removal proceedings. Thus, either outcome would inflict irreparable, harmful consequences on the plaintiff. So, there we go. All right. Finally, as to the third and fourth factors, which are substantial injury to the other party and the public interest. And again, they're going to weigh them together, which, like I said, sometimes they just mash these all together. The district court, it analyzed together, the district court held that the balance of equities and public interest. So here they're calling it the balance of the equities, where they're just going to balance public interest against the interests of the defendants. And that makes more sense when the defendants are the government, because balancing the public's interest against the government's interest does feel like it can be, like a scale. District court reasoned that plaintiffs sought relief only for current parolees. And the government did not provide a substantial reason that justifies forcing individuals who were granted parole to leave prematurely. So there was no reason to make, this is only applying to the people who already have it, and so allowing them to finish out their time period did not really harm them in any way. It further stated it was not in the public interest to summarily declare that hundreds of thousands of people are no longer considered lawfully present, such that these individuals cannot legally work in their communities or provide for themselves and their families. So basically, to suddenly make these people unlawfully present when they're already here would be contrary to the public interest. That's what the district court judge said when she was going through, or he, I'm not sure, I think they may have said she, I'm not sure, was going through those 4 steps. All right, government appealed. A few days later, the government moved to stay the district court's order pending appeal. This court denied. Interesting. So the First Circuit denied the stay, but the Supreme Court granted the stay. So, that was, when was that? Supreme Court granted the application, staying the district court's order pending cert. So that was back in, I want to say, May. So that was back in May. And that was one of those big, scathing Jackson, one of the first big, scathing Jackson dissents. All right. So now we have gotten into section 2, if you can believe it. But we are actually pretty far into it. So we've gotten through a lot of the meat of this. So we're in the discussion section. We ordinarily grant or deny a motion for preliminary injunctive relief for abuse of discretion. And that is what we call it's another question about standard of review. How are we going to review this? We are going to review this for abuse of discretion. Did the district court abuse their discretion when they issued this injunction. I'm going to go through a bunch of law explaining all of that. I'm going to see if any of this is super important. So first, the government says that the district court erred when it said that it could review the secretary's decision, which that never sits right with me. And second, the government claims the plaintiffs did not demonstrate a strong likelihood of success. So those are the two arguments. And then we're going to talk about jurisdiction for a minute, which I might just skip because A, B, yeah, I think I can just skip over jurisdiction because I don't think we need to hear it. All right, so now we're going to talk about stay. Stay is not a matter of right. This is a really important thing. You know, one of these things where I read these cases almost every day, and I see this quote every time I read one of these, and you guys probably don't. So this is something that I see every day. There is a case called Noem v. Holder, and I think that's how that's pronounced. It's Nken, I believe that's pronounced. Pretty sure. But it is always cited in these cases because the line from it that's cited is that a stay is not a matter of right, even if irreparable injury might otherwise result. A stay is extraordinary relief. It's something that only is used in special circumstances. Now the problem is we're seeing a lot of stays these days. There's a ton of stays, and so that that case is feeling like it's getting a lot of exercise, but maybe getting ignored a little bit. But Noem v. Holder is cited in almost every one of these cases, and it's always that same line. A stay is not a matter of right. The burden of showing that the circumstances justify the exercise of discretion rests with the party requesting the stay. Here, the plaintiff. So the plaintiffs are the ones who have to demonstrate that this is, you know, worth doing. And once again, in determining whether to grant a stay, the court must consider our four things: whether they have a strong likelihood of success on the merits, irreparably injured without the stay, substantially injured the other parties, and public interests. So I'm telling you guys, those four things that I just wrote down for you, they come up over and over and over again. It's like written on the inside of my brain at this point. So the government contends that the plaintiff did not demonstrate a strong likelihood of success on the merits because the decision to terminate grants of parole is within the secretary's authority. So let's see here. And otherwise not arbitrary and capricious, which is another thing you're going to hear a ton of. Arbitrary and capricious all the time, you guys, over and over and over again. Arbitrary and capricious, arbitrary and capricious. When you're the government, you're not allowed to just do things because you feel like it. And you're especially not allowed to do things because you like one guy better than you like somebody else. And so to make sure that you're not doing stuff because you feel like it and because you're showing favoritism, whenever you do anything, you have to show your work. You have to explain why you did everything and make a list of the reasons that you chose for everything you did. Everything. And if you don't do that, then your decision is considered arbitrary. You made a decision without explaining why you chose this over this. You always have to explain why you did it. And so making a decision that is arbitrary and capricious is never allowed, because then the government would be allowed to pick favorites all the time, and they're not allowed to do that. That is just like rule number one. Oh yeah, by the way, we're really low. Can somebody tap for me? We're very low on likes. I didn't even notice. Okay. So that's one of the things that the defendants are saying here is that this was arbitrary and capricious, or is not arbitrary and capricious, rather, whatever. All right, so first we're going to talk about the authority to terminate parole. We begin with the government's assertion that parole permits en masse termination of parole. District Court held that the statutory text contemplates termination of parole on an individual rather than a categorical basis. So let's see here. Wait. So remember that it's the argument, one of the big arguments going on here is whether this is supposed to be granted and again removed on an individual basis, whether they're supposed to go through case by case and decide you get it, you get it, you get it, or whether they can say this group of people gets it or not. And the Biden administration kind of set up this group that they said would get it, and this administration is saying you can't do that. But the court is, but then the question is, well, but when you say you can't do that, can you just take it away from them without going through and saying you no longer get it, you no longer get it, you no longer get it? Can you say this whole group no longer gets it if your argument is that they should have gone through one by one to begin with? So that's sort of the competing arguments going on here. And the district court said essentially that kind of if the argument's going to be that you have to go through one by one to give it to them, then you have to go through one by one to take it away. And so they said the statutory text contemplates termination of parole on an individual rather than a categorical basis. You can't take it away from the whole group. You have to take it away one person at a time, and that's not what you did. But here's the thing. This court doesn't agree. This court says, we read the statute differently. Here comes the blue pen. This is my conclusion marker. This is my conclusion highlighter. We read the statute differently. We conclude that the plaintiffs have not demonstrated a strong likelihood of success. Remember, number one, you've got to prove that you are likely to succeed. As customary, our interpretation of any statute begins with the text. And so then we're going to go through a whole, this is just like the basic concepts of statutory interpretation. A statute is ambiguous only if it admits more than one reasonable interpretation, blah, 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 blah. I know that's a lot of blahing, but that is a whole other conversation that we are not getting into right now. As we said earlier, this section of the INA, of the Nationality Act, empowers the Secretary with the discretion to parole into the U.S. temporarily under such conditions as she may prescribe. But the Secretary's parole authority is not limitless. The statute specifies that the Secretary's decision to grant parole must be carried out only on a case-by-case basis. Okay. And for urgent humanitarian reasons or significant public benefit. Those are two reasons that this has to be done. On the other hand, the clause describing the Secretary's authority to terminate, to terminate any grants does not contain the same limiting language. Indeed, Congress allows the Secretary, we'll go with orange. This is our analysis marker. Congress allows the Secretary to terminate parole when the purposes of such parole have been served. So if the Secretary thinks that, whatever reason we created this parole has now been reached, then the Secretary is allowed to terminate parole. When Congress uses limiting language, as it does in the first part of the clause, the part that sets it up, we must give effect to not nullifying Congress's not nullify Congress's choice to include limiting language in some provisions but not others. We have to note that Congress limited this language here but didn't limit it somewhere else. That is very, very important. If they narrowed the powers here and didn't narrow them over here, that is very, very important, and we need to note that they did that intentionally. The statutory text, therefore, favors an interpretation that the case-by-case requirement only limits the Secretary's discretion to grant parole. So, moreover, one cannot necessarily presume that termination must proceed case by case just because granting of parole proceeds case by case. So just because going in, you require case by case basis on the way in doesn't mean that it requires it on the way out. Let me hit that with my blue. Granting parole requires a two-pronged judgment. And we're back to green. Laws. Requires a two-pronged judgment on the part of the executive branch. One, that there exists a policy that will be furthered by the granting of parole meeting certain conditions, and two, that the particular applicant satisfies these conditions. So hold on. Granting parole. Exists a policy that will be furthered by the grant. Oh, they're just kind of putting it backwards. I see. They're just saying the same two rules, but kind of putting them in reverse. All right. What do we say here? Once the executive branch determines that achieving the policy aim is no longer possible or desired, then it takes no individual determination to ascertain those persons for whom it can no longer be said parole furthers the country's interest. So there's no requirement that they go through the same process again. Once they've determined that the policy is no longer there, they don't have to go through the people to make sure that each one of them are no longer meet it. However, the district court emphasized that it referred to singular rather than plural in the grants of parole. The district court determined that the way in, the antecedent, singular, also extends to terminations on the way out. For the text continues using singular when referring to the conditions upon which the secretary may terminate. As a result, the district court said the termination of parole requires an individualized rather than categorical analysis. So basically, the district court said that, well, they're not using plural here. They're always using the singular. And so therefore, they intended that every single one of these be done on an individualized basis. But the Court of Appeals here says not so. That the provision of text is written in the singular form does not resolve the question. And now we are going into a grammatical rabbit hole that I think we're going to skip over a little bit because I think it might be a little hard for me to read this out loud and stay with it. But they're going into the Dictionary Act now, which is, we're getting deep here, guys. We are shoveling into this rabbit hole at this point. I'll tell you what, I'm just going to go ahead and read this because some of you might want to hear this. The Dictionary Act instructs courts that in statutes, words importing the singular include and apply to several persons, parties, or things. We do so unless the context of the statute indicates otherwise. Context of the statute here does not indicate that the secretary must engage in individualized terminations of parole. So essentially, just because it stays in the singular doesn't necessarily mean that we have to continue reading it in the singular unless the statute says so. So there is a Dictionary Act that I don't know if I've ever read, and I'm going to be... Oh, yes, I have. It's 1 U.S.C. Section 1. Yeah, I have. Okay. Never mind. Yeah, I've read that. All right, so legislative history of the case-by-case language also weighs in favor. So now they're going to go back and look at when this was written in the first place. The House report said that they intended the way in basically to be used on a case-by-case basis. Yeah, and didn't... Okay, yeah, we're going to skip over. I don't need to read all of what the case says here, or what what Congress argued about. Because the text and legislative history favor the government's position, we conclude the plaintiffs have not demonstrated a strong likelihood of success in establishing that it requires the secretary to end grants of parole. by otherwise interpreting the applicable statutory. So I know I'm skipping over some stuff. Part of that is just the fact that we're, an hour into this, but, or maybe longer. Although we are getting close to the end. So, sufficient explanation of the termination. So having determined that the statute does not require individualized termination. So here, in case you've missed this point, the general point here is that, yeah, you do have to decide on the way in when you're putting people into this on a case-by-case basis, but you do not have to do it on the way out because we are providing this as an option to people because of some big policy thing that we're trying to fix. And as soon as that big policy thing no longer exists, it no longer exists to all of the people we've allowed in under this. We don't have to go through one at a time and decide that anymore because we know that it applies to all of them. So that's what they said. And once again, by the way, I think down at the bottom, you can get the morning report mugs if you guys are interested with my Aloha Friday duck, which is how I'm trying to keep my my things sustainable here. All right. So, and the other thing is, if anybody wants to over on the YT, because I've heard once again all of the rumors that like something's going to happen to TT. I am available on YT. You can click on my profile and follow the link, and it'll take you over to my other place. I don't want to say it out loud because I think it hurts the thingy, the algorithm. All right, having determined the statute does not require individualized termination, we now consider whether under the APA, the Secretary's decision to terminate parole early. So now basically they're going to go through the APA evaluation. So here's the deal with the APA. It's kind of hard to explain, but the APA is this enormous motor in the middle of the government. And every single thing that goes through an agency, the APA is basically the engine that tells it how to operate. And so whenever... And that is the best I can explain. When, for example, let's say that I work for some little agency that controls the ink in these pens, and I want to change whether it's legal to add a particular ingredient. And hey, Harambe, and in order to do that, it's a regulatory thing. I have to change the regulation. In order to change that regulation, I will probably have to write a new proposed regulation and put it online somewhere in particular. I will probably have to post a copy of it somewhere. It'll have to be up for 60 days. We'll have to have, 2 in-person public notices where people are allowed to come in and give their feedback on the change in the regulation. And if nobody objects, then 60 days later it'll become a regulation or something like that. That whole process is explained in the APA. The APA tells agencies how to do anything. If a member of my agency I'm trying not to say that I fired them, but let's say I fired them. Let's say let's say I'm not happy with their performance, and and the APA will tell me how to address that. Whether I need to, actually probably I will have, it's even weirder because I will probably have a very specific set of rules from my agency on exactly how we deal with somebody whose job we don't like, who we don't think is doing the job very well. I'll have to sit down with them and have a talk with them and, whatever. And if they still don't do it better, then, I'll get my supervisor and we'll sit down together and have a talk with them or whatever. The APA will tell me how to write those rules. The APA is the engine at the center of the government that tells you how to do everything that the government does. So that's the best I can do. So anytime you see somebody saying that something has violated the APA, it's because it means that whatever part of the engine goes through this particular agency is not following the middle of the engine properly. That's the best I can explain it. It makes a lot more sense when you work for a much smaller government that basically uses a copy of the APA, which I did at one point, and I'm really glad I did, because I never would have understood the APA if I hadn't had to deal with our kind of small version of the APA and seen it in action all the time. Now I've dealt with it a lot, it makes a lot more sense, and so when I come back to the Fed and see the APA, it makes more sense, but it's hard to explain. So the APA instructs a reviewing court to set aside agency action that is arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with the law. An agency's decision is arbitrary and capricious if the agency relied on improper factors, disregarded an important aspect of the problem, offered an explanation that runs counter to the evidence, or when a reasonable explanation for the agency's decision cannot be discerned. Remember that agencies the government has to tell you why it's doing things so that you can hold them accountable for their decisions. You can make sure that they had a reason for doing stuff and they weren't just doing it because their buddy wanted help or something like that. They have to show their work all the time to make sure that they're not showing favoritism. And if they don't show their work, that is called arbitrary and capricious. It means they've just made a decision that's not based on anything. The APA is part of making sure that they don't ever do that. District Court determined that the plaintiffs were likely to prevail on the argument that the decision could not stand because it was obvious legal error. Secretary's explanation rested on the premise that the INA which is the Nationality Act, prohibited use of expedited removal proceedings for a prior parole recipient who'd been here continuously for 2 years. So this is the argument that they were worried that if people had been here too long on these parole things, on parole, that they would no longer be able to remove them through expedited removal, and that they would essentially become like what did I say before, squatters, and they would get like some extra squatters' rights. They'd been here too long, and the government was no longer allowed to like get them out quickly, and so they weren't allowed to let them stay through their entire 2 years because they were worried they were going to lose the ability to move them out quickly. DHS explained that it sought to terminate parole early rather than permit the parole to naturally expire, to minimize the number of people who would have otherwise been ineligible for expedited removal. But the district court said that that was not the case. That the district court said that switch marker colors. That the district court basically said that no matter how long the people had been here, they were not subject to expedited removal, which we're about to find out the answer, but I am pretty sure is not correct. We address this issue mindful of the plaintiff's burden in the context of a stay to demonstrate a strong likelihood of success. We cannot agree that plaintiffs have made a strong showing here. So remember, this is not a final decision. This is still a stay. The INA permits only those who have not been admitted or paroled into the United States to be subject to expedited removal proceedings. Okay. Wait, the INA permits only those who have not been admitted or paroled to be subject to expedited removal. The parties reasonably disagree on the meaning of have been paroled in this context. Plaintiffs in the district court reasonably read the language to mean those who have been granted parole at some point in the past. I don't think I disagree. So I was wrong. And this is how we learn. Whether or not that parole has since been terminated. Viewed this way, no prior recipient of parole can be subject to expedited removal proceedings, which logically does make some sense depending on how you look at it. So my question was whether a paroled person was actually considered all the way in the country or not, and I thought there was some question about that. They kind of were here, but not technically here. But if that's not correct, then once they're here, no, you can't use expedited removal. The government, on the other hand, reasonably reads have been paroled to refer to those with current status of being paroled. Under that reading, the statute clarifies that those people who are currently paroled may not be subject to expedited removal proceedings. However, it does not impose a categorical ban on use of expedited removal proceedings. For those whose past parole has since been terminated. Well, that's just confusing. Both readings are plausible, as plaintiffs point out. Parole can refer to both a manner of entry and a status. Okay, that just makes my head hurt. That's going to end up in the Supreme Court, guys. That is a... That's confusing. They can both be used to denote an act that has been completed and to denote an act that continues to be true and is present. Ooh. Although both sides offer regulations in support of their preferred or proffered interpretations, the fact that different regulations appear to support both interpretations does not shed light on which interpretation Congress intended. No, it does not. So I hope this is making sense. I don't think I understand. I don't think I do either. But here's the general idea, guys. It says that if you are paroled into this country, allowed here under this parole program, you cannot be subject to expedited removal. Expedited removal only exists if you are still essentially standing at the border. My understanding up to this moment was that people who were paroled into the country were not fully admitted into the country, and essentially they sort of carried a bubble around them of the border with them. So they were never all the way here. And so even though they walked around in the country, they never were admitted all the way, and so when they were sent out, they could be sent out really quickly with that expedited removal, because they'd never been fully admitted in the first place. I know that sounds weird, but that was my understanding up until now. There are a few cases where that is the case, where there's this sort of bubble of the border that walks into the country with you. It's very specific circumstances, and it's been a long time since I studied this stuff, so trying to remember what's what. But I thought this was one of them. Here, what they're saying is there seem to be some contradictory pieces of law here that say different things, and that parole can be both. What do they say here? It can refer both to how you entered the country, you were paroled in, and a status, as in I am here on parole, I'm here paroled in this country. And it seems, if I'm getting this right, that different rules have been written attached to one of those meanings and attached to the other meaning that put different rules about expedited removal, as though one of them is bringing the bubble with you and one of them is not. And the court is not really sure what to do with this. And neither am I. Because that is very confusing. I'm not going to ask you whether that makes sense, because it doesn't. But does it at least explain what the confusion is? I'm going to ask you, Oregano, because I know you can say whether that at least helps explain where the confusion is.
I'm not entirely sure which is which. My guess is that if you have entered the country, if it's using the definition where you like walked through, paroled with this bubble, that you are still allowed to be removed through this expedited removal, real fast, out. And that's what the regs are written about. Like, you know, someone who was paroled into the country and came in through that system. But then other rules talk about someone who is here as a parolee, as though they cannot be removed through that. And those are contradictory rules. And so the court's not really sure what to do with it. But the big problem here is that because the court's not sure what to do with it, and because the question they have to answer, we're going to swing over here again, guys. Sorry. Hopefully you've been here, some of you have been here long enough to remember what I'm talking about here. We're going to mirror you back again. So for those of you who were here earlier, because the first question we have to answer here is the likelihood of success on the merits. And because the court isn't sure here what this means, they can't say that you're likely to win because they don't really know what it means. And that's what I think what they're trying to say here is that, you know, at best we can say that this is confusing. And that if this gets up to the Supreme Court, they might go one way or the other. But we definitely can't say that it's likely that you're going to succeed because these laws don't make any sense and they're not clear. And that's the best we can say right now. So you're not likely to succeed, and especially because this is such a little, we've already talked through the big arguments. We're now down to the little arguments here. They're not going to go as far as to say that you're likely to succeed. Hopefully that is just about as clear as mud. I wish I could make it more clear, but sometimes you just can't. I'm not totally sure I get it, but that's the best I can do right here. But here's what this, so since the government's interpretation of the statute is persuasive enough, we cannot discern a clear legal error. As the district court put it, DHS's reasoning, well, whatever. So we therefore are unable to conclude that the plaintiffs made a required strong showing that the agency's action was arbitrary and capricious, an abuse of discretion, or otherwise in accordance with the law on this basis alone. Now remember, guys, that this is not a final decision. This is a stay. And that's the whole point, that this isn't a full deep dive into all of the arguments and stuff. This is sort of a surface look at it. And so, but the problem is once you unstay something like this, all these people are going to be sent home. So it's a pretty big stay. So it's like, So saying that this isn't permanent is a bunch of people are going to be put in a situation where they're going to be suddenly unlawfully present when they weren't unlawfully present yesterday, and they've got to decide whether they're going to just sit around and hope, or whether they're going to try to get a plane ticket home. So. It would be a little bit disingenuous to say that this isn't a final decision, because for a lot of people it probably will be, but technically in the court sense of the word it is not a final decision. This is more of a, trying to make a decision based on what we have. So unlike the Supreme Court decision in Region, now we're going to go through. All right, finally, we note that the Secretary explained that humanitarian considerations are best addressed on a case-by-case basis because that approach would be more consistent with the statute and would take into consideration each person's specific circumstances. Although this statement is somewhat conclusory, when read in combination with the other reasons given throughout the termination notice, it does not seem so deficient as to enable the plaintiffs to make a strong showing of likelihood on success of the merits. So this is the whole point. Again, we don't have to win, but we do have to show that we're probably going to win, and there's just not enough here to demonstrate that we're probably going to win here for them to enforce this in the meantime. It is difficult to fault a conclusory explanation for a change in policy when the basis for the policy's establishment was similarly conclusory. In sum, we hold that the plaintiffs have not made a strong showing that they are likely to succeed in showing that the Secretary's decision to terminate this parole program exceeded her discretion as authorized by the INA. We also conclude that plaintiffs have not made a strong showing they are likely to succeed in demonstrating that the termination was arbitrary and capricious and insufficiently reasoned. We recognize the risks of irreparable harm. So that's step 2. So there's risk of irreparable harm. Parolees who lawfully arrived in this country are suddenly forced to choose between leaving in less than a month, a choice that potentially includes being separated from their families, communities, and lawful employment, and returning to the dangers in their home countries, as well as being potentially abandoned abandoning their APA claims, or staying after the loss of their legal status, which means the risk of removal proceedings and detention, the loss of any work authorization, and potential effects. So, they're going to be here, but they're not going to be able to work anymore. But absent a strong showing of likelihood of success, the risk of such irreparable harm cannot by itself support a stay. Only if they're, really that first one is super important. All of them are considered, but that likelihood of success on the merits has to be there. And we're back to Noem, which says that the 2 stay factors that are most critical and require more than a possibility. The first stay factors are the most critical. Given this conclusion on the most critical factors, we need not consider the final 2 factors. Because each side has a strong argument about the harm they face and equities involved, our resolutions ultimately turn on the merits and the question of who is likely to prevail at the end of the litigation. For the foregoing reasons, we vacate the lower court's decision and remand for further proceeding consistent with this opinion. So that was on Friday. That is the entire case. You guys have worked through with me. And I know that we had that very confusing part in there, but by and large, I think that the overall point here is that, and the most important thing to walk away with here is that this rule was written, unlike the TPS, unlike the temporary protected status, which was designed to always be a certain length of time. TPS status, which incidentally, this exists for people from Venezuela. People from Venezuela can also get TPS status, so at least some of them are probably able to switch over to TPS. I'm not sure. But that TPS, which is designed, it was written with the purpose of creating a sense of stability for a period of time. Parole is not written with that same thing in mind. And that is, I think, what the court is going through here. And once again, I think it's important. I said this, it's been 2 hours now, but the judges here are a Biden-appointed judge and an Obama-appointed judge. This is not a political decision. This was a well-reasoned decision that, looking at the law, it was required on the way in, when you decide to grant this to somebody, that it's done on a case-by-case basis for a public benefit. But that public benefit could change. And if it does change, it's suddenly going to change for the entire group of people. And it does not seem to require that case-by-case basis when you're changing it back. The implication from the district court judge was that because it requires case-by-case on the way in, it would require it automatically on the way out. But it doesn't say that, and it doesn't really seem to imply it either. So I think this is pretty well reasoned. I may sleep on it and change my mind, but having gone through it, that feels like a reasonable response. It's not, it's not good news for these guys, and I obviously don't, I'm sorry for them, but I do think it appears to be a pretty well-reasoned opinion. I am still not certain about that one piece where we got lost in there about, but I don't think they knew either. I think they were confused as well, and that was the whole point, was that these regulations are a little contradictory, but as a result, and as especially because it was such a minor point, they weren't able to determine that there was a strong likelihood of success because the regs seemed to go in opposite directions. So that, I think, is where we are here. And now, let's see, where are we? 7:40. God, I am exhausted. I still have to write the morning. I have to write a 3 or 4 minute, probably 2 or 3 minute version of this for the morning report for tomorrow. But hopefully that made some sort of sense. And I do think, keep your eyes out, guys, for these 4-part tests on, because we've talked so much about preliminary injunctions, and it's always going to start with that likelihood of success on the merits and the irreparable injury are going to be your 2 most important things. And watching them argue through those 2 points, it's going to happen every single time. They're going to go through those 2, and the district court's going to go through it, Court of Appeals is going to go through it, the Supreme Court's going to go through it. Every one of those Supreme Court cases where they talk about a stay is going to talk about likelihood of success on the merits and irreparable injury. And whenever you see those scathing dissents from 6 justices said, yeah, we're putting the stay and don't say why, and then you get this angry dissent from the other 3 justices, it's still going to follow the same thing. It's still going to say why they think there was a likelihood of success on the merits. And so it's always going to be following that same pattern. And so that gives you something to kind of look for. They're going to do likelihood of success on the merits, irreparable injury, and then either they're going to go into substantial injury to the other parties in public interest, or what they call balancing of the equities, which is essentially the same thing. And they're going to do it with anything equitable. So injunctions, stays, anything like that, they're going to go through this same basic framework. So keep your eyes open for this. You're going to see it over and over again. I'm going to explain it to you again and again because it's just super important, and it helps to see, when you see something that is this long. I mean, you guys saw that I've been doing this for 12, 13 years, and it took me that long to get through this thing. This was tough, and they're always tough. But having these little signposts makes them a little easier to read. And so knowing the signposts and knowing what to look for, and as you go through, noticing when they go from talking about likelihood of success on the merits, when they start instead talking about irreparable injury, and you'd be like, okay, we just flipped chapters. Really does just demystify it a little bit and make it feel a little bit cleaner and a little bit easier. So, all right, guys. Well, thank you all very much for coming in tonight, and I appreciate a couple of you bought mugs, which I appreciate. Thank you very much. Got our duck mugs. Yeah, I will be back with the morning report tomorrow morning. I think we have a couple. Thank you very much, Oregano. I got a couple cool stories coming. I know it'll be this one and a couple others. So everybody have a good night, and I will see you all tomorrow morning. All right. Bye, everybody.